Welcome back. In this final lecture topic, we take on the question of the formation of a sales contract. What is necessary to form a sales contract? And obviously, this is a very important point, because if the contract does not come into existence, then we are going to be forced to use rules that are not present in the UCC. So UCC Article 2 governs contracts for the sale of goods. The UCC aims to promote the completion of business transactions. We know that the Model Code, the Uniform Commercial Code, was created to facilitate commerce, to encourage commercial activity. And therefore, the UCC wants to find a contract. The UCC wants the parties to enter into a contract. So unlike the common law, which makes it much more difficult to enter into a contract, the formation elements for a sales contract are easier to meet, and they don't require the same level of intent or commitment that is required for common law contracts. But of course, remember, the parties are always free to create their own terms in their contract, meaning you can, in your contract, control things like offer, acceptance, and consideration. But if the contract is silent as to those issues, we turn to the UCC, and the UCC encourages the notion of a contract existing. So today we're going to look at the requirements of a valid contract, and at the end of the lecture you should be able to answer the following questions. How does the UCC change common law requirements for a valid offer? How does it change common law requirements for a valid acceptance? And what changes does the UCC make in other areas of contract formation? So let's take this big topic, the UCC and the formation of agreement. Now, as I said, the UCC aims to promote the completion of business transactions. The formation elements for a sales contract are easier to meet than a contract under the common law. Article 2 allows for an enforceable agreement to exist if the conduct of the parties indicates some basis for a reasonable person to believe a sales contract exists. So what the UCC says, in essence, is that if two parties engage in conduct that looks like a contract, but yet there is some technical reason why a contract would not exist, the UCC is going to take the position that they are in a contract. As long as the parties behave in accordance with the terms of a obligation that they believe to be the contract, Article 2 will find the existence of a contract. So in any question of does a contract exist or not, the UCC favors the idea of yes, a contract does exist. And then, so we're going to talk in here about what does the UCC, once the UCC has concluded that a contract exists, what are the consequences of that belief? So the Uniform Commercial Code, I said it allows a contract to be enforced based on things like past commercial conduct. How have the parties behaved in the past? What sort of correspondence have the parties exchanged? Or what sort of verbal exchanges, oral conversations, have occurred between the parties? And what are the standards and norms of the industry? So a contract can be enforced even if it would be invalid under the common law if I can show that the parties in the past have behaved in a way to indicate that a contract exists. So a contract under the UCC is easier to arise. Let's talk about specifically the question of agreement, mutual assent. Now we said mutual assent is composed of offer and acceptance. So we're going to start with offer, and we're going to talk about how the UCC modifies the law regarding offers. Now, what is an offer? An offer refers to a promise that one party makes in exchange for another party's performance or another party's promise. So an offer is really an invitation to enter into a contract on certain terms. An offer is a statement of the terms on which the offeror is willing to be bound. So if in that hypothetical, I say I will buy your computer for $500 next Tuesday, that's my offer. I have offered to be bound to that agreement. If next Tuesday you want to conclude the transaction, I'm going to be bound by that offer. So it's a statement of the terms. It's an invitation to enter into a contract. Now, the expression of an offer can take different forms. Offers can be put in a letter, in an email, in a verbal exchange, or even through conduct, the way parties behave. And the offer communicates the basis on which the offeror being the party making the offer, is prepared to contract. I am prepared to pay you $500 for your computer. Ordinarily, an offer can only be the basis of a binding contract if it contains all of the key terms of the contract. According to the common law, any missing term could invalidate the contract. Under the UCC, we can have a valid contract even if there are important terms that are missing from the agreement. So when I say the UCC makes it easier for parties to enter into a contract, the UCC wants there to be a contract. One of the key ways it does so is by providing default rules to govern those open terms, those missing terms of the contract. So let's look at offers with open terms. Sometimes the parties overlook or unsure about some key element of the contract. Quantity, delivery, payment terms, price of the goods. Those are all very important factors. And in a common law contract, if those factors are missing from the offer, then there's not going to be a contract. However, under the UCC, these missing provisions, what we call open terms, are acceptable. If there is evidence that the parties entered into a contract and there are other terms that are sufficiently articulated to provide a basis for a remedy in case of a breach. So the UCC will supply rules to fill in those open terms. And the parties will be bound by those rules because the UCC finds that there is a contract existing, even in the absence of what would be very important terms like quantity, delivery, payment terms, or price. So the UCC's approach toward open terms is an example of its gap-filling role, meaning the contract is unclear or does not mention quantity or payment terms or price. The UCC will supply those items. The UCC will find that there is a contract exists, and it's going to supply the answers to those missing provisions.